The poll.
Eugenie Sage.
Good on you, Curly.
Thank you, Mr. Chair. Now, Mr. Chair, this part of the bill deals with a review of ECAN's powers and functions under Part 3 of the Principal Act. That part of the Principal Act deals with water conservation orders. And in the Green Party's view, there is no need for the review of water conservation orders in 2016 if the government was committed to doing something now, and it should be committed to doing something now, because in Canterbury we have a legal situation with water conservation orders that the provisions that apply under the Resource Management Act in Canterbury are quite different from anywhere else in New Zealand. Outside of Canterbury, water conservation orders, their purpose is to recognise and sustain outstanding amenity or intrinsic values and to preserve as far as possible in its natural state any water body that's considered outstanding and to protect habitat, fisheries, recreational, scientific, ecological and other characteristics of a river or lake that are considered to be outstanding. Yet in Canterbury that does not apply. Those provisions have been substantially weakened by the Principal Act, and when officials' advice was that there was no justification for continuing this different regime in Canterbury, why does the bill continue it? Why doesn't the bill repeal that? And when we were debating Part 1, I challenged the Minister to answer the question as to why ministers have decided to go against the advice of officials, and I repeat that challenge. Because it is not legally good practice to have two different regimes applying in different parts of the country. And, Mr. Chair, New Zealanders love our wild and scenic rivers. They love rivers like the Rakaia, the Ahuriri, which are protected by water conservation orders. They're an important part of our way of life and our identity, and a place for people to enjoy recreationally. And when we're losing wild and scenic rivers internationally and in New Zealand because they're being channelized with stop banks for flood protection purposes, they are being taken for irrigation to turn fields green, it's really important that we protect the rivers that remain. This bill certainly repeals the references to the Huranui Water Conservation Order, and that's because Fish and Game withdrew their application for a water conservation order to protect and preserve that river because they recognised that it wouldn't be much value given the weakened provisions that apply. Mr. Chair, there have been no other applications for water conservation orders since the Principal Act was passed. The bill should reinstate the Part 9 of the RMA, which applies elsewhere in New Zealand. Because it doesn't, it means that we are not getting the protection that some of our Canterbury rivers deserve. In 2010, I rafted the Clarence River. That's a multi-day rafting trip on one of the most scenic and enjoyable Grade 2 and 3 rafting rivers in New Zealand. It starts at Lake Tennyson. You go through, you start near the Acheron Homestead, and, sorry Mr Chair, people start near the Acheron Homestead, and the river is nature's own highway. It goes through the tawny tussock lands of Molesworth, through Clarence Scenic Reserve, down that fault line between the inward and seaward Kaikoura's. The Clarence River deserves to be protected by a water conservation order because it's one of our outstanding rivers. Yet because the South Bank is in Canterbury and the weakened provisions in the Principal Act would apply, why would Forest and Bird or Fish and Game apply to protect that river? And, Mr Chair, we have seen no progress on protecting our outstanding wild and scenic rivers under this government. We had two major reports on water conservation orders by the New Zealand Conservation Authority and the Parliamentary Commissioner for the Environment last year, recommending greater attention and expansion of the ways in which they work, their application to the land in the catchment. Yet what has this government done? Absolutely nothing. And that's because this government does not care about our rivers except as a source of irrigation and except to generate hydropower. It's had the opportunity to repeal those sections in the Principal Act, and as Fish and Game said, that would be a demonstrable example of good faith in restoring the law in Canterbury as it prevails elsewhere in the country, yet the Minister has failed to take that opportunity, the government's failed, and there's been no explanation from ministers on the opposite government benches as to why it's rejected that advice when it would be a sign of good faith to restore the Water Conservation Order provisions. Mr Chair, this bill fails both in protection of the rivers and in democracy.
Dr Megan Woods.
Thank you, Mr Chairman. And I'd like to acknowledge the contribution we've just heard from my fellow